Good afternoon, everyone, and welcome. It's a pleasure to have you all with us for the first session in our three-part webinar series on advocacy. Advocacy is at the heart of what we do as family lawyers, and I think it's one of those things that most of us all wish we were better at doing. And that is exactly what we're going to be hearing about today. My name is Dina Palethorpe, and I'm a family lawyer, and I'm the coordinator of LEAP's Family Law Forum. Before we begin, I'd like to acknowledge the traditional custodians of the lands on which we're meeting today. For me and for Karen, we are dialing in from Sydney, so that's the Gadigal people. I pay my respects to elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander people joining us today. We are incredibly fortunate to be joined by Karen Shea, who not only is a respected barrister, but is the advocacy lecturer at UNSW. Karen was admitted to the bar in 2018 and prior to that worked as a solicitor in family law for 18 years, including almost a decade as a family law advocate at Legal Aid New South Wales. Karen appears extensively in the FCOA, the Children's Court, the District Court and the Supreme Court in complex matters involving children, care, protection and adoption. Since 2021, Karen has been recognised on the Doyle's Guide as a leading junior counsel in both the family law and the parenting and children's matters categories. We'll have a few minutes at the end for questions. If you do have any questions, please feel free to put them in the Q&A chat box and we'll come back to them at the end. Otherwise, it's a privilege to have Karen with us to run this series on advocacy. Please join me in welcoming her.
Thank you, Dina. Thanks, Dina. Can I just confirm that you can hear me? I think you're on you're on mute, but I'm assuming that that's
Yes, I can.
Okay, all good. Thank you. Thank you, everyone in the virtual audience. I can't see anybody, which is quite disconcerting. I'm just speaking to a blank screen, and I can see Dina in the corner, but I'll assume there's people out there listening to this. Thank you for joining us in what is the first in a three-part series in relation to advocacy. As Dina said, I'm at the bar. I've been at the bar for 7 years now, and prior to that I was at Legal Aid for nearly 17 years. And a large part of that time was spent, well, pretty much all of that time was spent in the family litigation section, and a large part of that was as an in-house advocate. Advocacy is something that's very close to my heart. It's what I do as my job, obviously, but what I enjoy it a great deal, and I also very much enjoy teaching it. So hopefully I can pass on some information today that will be of some assistance to people. I appreciate that we have a large audience with a wide range in experience, and in particular an advocacy experience. I assume most of you have had some experience doing your own advocacy. Some of you might have I assume run your own interim hearings. Some might even have run your own final hearings at some stage. And then I also expect that there'll be some parts of the audience, people in the audience who are less experienced and may not have had much time on your feet. So I'm trying to cater to a very broad audience today. I'm hoping very much that there'll be something in the series and in today's session for everybody. Certainly every time I teach advocacy, I'm reminded of something or I learn something new. So it's as I'll speak about very shortly, it's a developing sort of skill set, and you never stop learning, which is part of why I love it so much. All right, so without further ado, Dina, can I ask that we flick to the next screen, and I can probably do that now too, control that myself. All right, so we talk about, I think the title of today's session was Advocacy, the Art of Persuasion, and that is often how you see it described as an art form. And I just wanted to I suppose, initially talk about very briefly why it is considered an art form. Because it's certainly not how I was taught to think about it when we started. It's certainly not in law school. As a junior practitioner, I certainly did not appreciate it as an art form. But when you think about it, it is very similar in many ways to arts like painting, playing an instrument, dancing, in the sense that it is a set of skills that can be learned, but that also can be developed and have to be developed with practice and with time. So in that sense, it is an art form. And you do get better at it with practice. And that's one thing that I really do want to emphasize today, that a lot of the things I talk about today and in the rest of the series will be first of all, familiar to you, particularly if you are experienced practitioners. It's not rocket science. And a lot of the time, the things that are covered in any advocacy course that you undertake will be very similar. So much of what I talk about today will first of all seem like common sense, fairly simple, and things you have heard before. But the hard part is the implementation of all of the things that I talk about. And it's the implementation that you will get better at with practice. And there is, unfortunately, no way to get better at it other than with practice. You can sit and read textbooks, and you can learn about the theory and the principles behind good advocacy. But to actually become a good advocate, you have to do it. And you have to do it more and do it regularly. And each time you do it, with time, it will get better, just like with dancing, playing an instrument, doing some form of creative arts. So that's why it's a good way of thinking about advocacy as being like an art form. All right. So putting the theories, putting that aside, just to introduce what I'm planning to talk about for the rest of this hour, I'm going to be going through what I consider to be some of the golden rules of advocacy. Now, these are my golden rules. They are not all of the golden rules. If I had a longer time, I would probably come up with a few more golden rules, but these are the ones that I consider to be very important. As I said, they will be familiar to most of you. At least some of it will be familiar to most of you, but it certainly doesn't hurt to be reminded of these things. And hopefully there will be something new in what I talk about that you'll be able to take on board. By all means, these are not the golden rules. They're not set in stone. Different advocates, different barristers, judges will have their own golden rules. But you will probably see some consistency between what I tell you today and what other advocates would say to you in terms of what they consider to be their golden rules. Okay, but please don't think that these are set in stone. They are just things that I, from my experience, consider to be important in terms of for any advocate, whether you are just starting off, whether you're an experienced practitioner and starting to do a bit more of your own advocacy, or if you're at the bar. It's the same rules, and it's just about the implementation of them. All right, next slide, please, Dina. Okay, so the first of the golden rules I want to talk about is case theory. For any of you out there who have perhaps been one of my students at uni or who have heard me speak before about legal practice and about advocacy in particular, I bang on a lot about case theory, but that's because it's so important. It's so important to being a good lawyer to start off with. So whether you're an advocate or not, understanding the concept of case theory and ensuring that in every matter that you undertake, you have a case theory is so critical to legal practice. But it's essential to being an advocate, because without a case theory, you have no direction. You have no purpose in what you are doing. And an advocate with no direction and no purpose is not a particularly good advocate, because the whole aim of advocacy is to persuade. And that's an important concept that you need to understand. A lot of people think about advocacy, and I certainly did when I first started. I thought about advocacy as being about arguing. That was all about arguing. And to some extent it is, because argument is the tool of an advocate. It's what we do, what we use to persuade. But the goal of advocacy is to persuade, not to argue. So it's important to think of it in that way, that's why we call it the art of persuasion. It's all about persuading the bench to give you what you want, or in other words, to give your client what they want. But if you are without direction or purpose, in other words, without a case theory, you're not going to get very far in terms of being persuasive. And I should have started off by saying the golden rules that I talk about, and I think there's 6 of them in total today, they're all about how to be persuasive as an advocate. So the first thing in terms of how to be persuasive is to have a case theory. There are many ways of thinking about what a case theory is, but the way that barristers get taught to think about it is it's all about understanding and having in your mind basically 2 main things. What do you want? In other words, what orders are you seeking? What findings are you seeking? And why should you get it? And the critical part is the why. I mean, knowing what you want is, of course, important. You can't stand up and persuade the court to do something without knowing what that something is. So you have to be very clear in your mind before you open your mouth as to what it is you want. Now, sometimes that can be very simple. If it's an adjournment application, it's a very simple thing. Sometimes it can be more complex. So understanding and knowing what orders you want or what findings you want, which is more nuanced than the orders themselves. What finding do you want? Do you want a finding that a parent poses an unacceptable risk, for example? Then that you have to have that clear in your mind, right? Because that's the end goal. When you think about it, that's the conclusion, that's the outcome, that's the end goal of what you're trying to achieve and what you're trying to persuade the court to do, okay? The question, though, is why should you get it, right? Because if you think about it from the bench's perspective, you've told the bench what you want. The next question from the bench will be why. And you should be able to answer that question with something beginning with because. If you can articulate, and what your case theory is the answer to the why should you get it question. It is the because broken down into ideally, I would say 3 reasons why you should get, or your client should get, what they want, or why the court should make the orders that you're asking for or make the findings that you're asking for. So that's how I think of case theory. Obviously, there's many different ways about thinking of it, but if you can think of it as being able to articulate what it is you want and why you should get it, in a structured, logical way, then that gives you your basic case theory. The other way of thinking about it is this, what I've got in the second line on the screen, which is conclusion, reasons, and evidence. And if I had a whiteboard, I would put conclusions at the top, then reasons underneath that, like a tree diagram. Okay, so the conclusion that you're asking for, let's say, for example, a finding of that a parent poses an unacceptable risk. Why? Because 1, 2, 3 reasons, okay, for example. Now, I say 3. Please don't quote me and say Karen Shea says I must have 3 reasons for every finding I seek or every order that I want. I'm not saying 3 is compulsory, but 3 is a good number. 1 is not enough, obviously, because if you don't get up on that 1 reason or 1 ground, then you've got nothing else, although sometimes that's all you've got. But also too many grounds or too many reasons why you should get what you want is also not good. Okay, so that's why I generally talk about 3, and most when you do most sort of advocacy training courses, they'll talk about having 3 reasons or 3 grounds for what you are seeking. It's a good number. It's not too many. When you first start off with advocacy as a junior, a lot of practitioners feel like they need to argue every possible reason or ground that's available to them, even if they're not very good ones, because they're scared that if they don't argue those grounds, if they just leave them, then they've missed something. Okay, so you'll get practitioners who argue everything that's possibly available. But the problem with that approach is that the less good grounds or the weaker reasons for why you should get what you want undermine the strength or the credibility of the good ones. So that's why I say pick your best 3, be brave, leave the others if they're not good ones. and just focus on your best, right? Your best 3, 4, whatever it might be, 5, whatever it might be. If you find yourself going into 6, 7, or 8 reasons or grounds for why you should get what you want, then you might be doing too much, and you might then be undermining the strength of your good arguments, okay? So what I do in terms of writing out a case theory is I write out what the conclusion is that I want to get to, what's the end point, what are the reasons why the court should agree with me, okay? So 1, 2, 3 reasons. And then under each of the reasons, if you imagine a tree diagram, under each of the 3 reasons, I then insert the evidence. What is the evidence that supports this ground or this reason or provides the foundation, right? Because of course you all know that as legal practitioners, whether you're solicitors or barristers, one of the rules is that you can't make a submission without evidence. And you'll find that in the bar rules, you'll find it in the solicitors rules, the legal professional rules. You cannot make a submission without evidence. And we all know that, right? But sometimes we get caught out. Sometimes I hear practitioners making submissions. A judge will say, can you take me to the evidence in support of that submission? And the practitioner won't be able to do it. All right. So you must remember that you must have evidence to ground or to be the foundation for the submission that you make. And so to think about it, if you look at conclusion, 3 reasons why you should get what you want, and in support of each of those 3 reasons, here is my evidence. It might be evidence from an affidavit. It might be evidence in a single expert's report. It might be evidence in a piece of subpoena material. When it comes to final hearing, it might be evidence adduced in cross-examination. And the benefit of structuring it that way or looking at case theory that way is that you can then identify what evidence you need, right? Where the holes are to support the reasons which get you to the conclusion, right? If you reverse the tree diagram, and I wish I had a whiteboard, but if you can imagine evidence down at the bottom, evidence to support the reasons which go to the conclusion, if you can identify that you're missing some evidence in support of a particular ground or reason, then you can fix that. You can plug that hole. You can make sure it's in the affidavit. You can make sure you get an affidavit from a witness to corroborate something. You can make sure you issue a subpoena to make sure you've got that material. You can make, and for those thinking about final hearing, that's where you identify what you need to cross-examine on. Because you don't cross-examine for no good reason. You cross-examine, and we'll cover this a bit in the 3rd session, you cross-examine for a purpose. And one of those purposes is to get evidence out to support your case. So you might find that you have a gap, you have a hole in the evidence that you need in support of a particular ground or reason, and you might need to plug that hole at final hearing through cross-examination. Okay, so it's a really handy way to organize your thoughts. Okay, and a big part of being a good advocate is being able to organize your thoughts, because we deal with really complex matters, lots of material, lots and lots of facts and dense material. Part of your job part of our jobs as practitioners, and particularly as advocates, is to assist the court by sifting through all of that and organizing it in a way that makes sense. And what makes a good advocate is one who can organize the material in a way that makes sense, that is logical, and that supports the conclusion that they want to achieve. So that's what I'm talking about here, right? I'm talking about having a case theory that, as I've said on the slide, it provides a structure for your submissions, and I'll come back to talk about the importance of structure shortly. It provides a structure for your submissions. It ensures that you have a logical argument, right? Because arguments that are not, well, it ensures that you have reasons for the conclusion that you're asking for, right? So that it's logical, right? And that your reasoning is supported by evidence, which is essential. Your case theory is your starting point. I don't see how, as a solicitor, you can draft an affidavit without a case theory, because how do you know what evidence you need to put in the affidavit without knowing where you're going with it, right? What's the conclusion you want? What are the reasons, and what evidence do you need? You need to know that in order to know what to put in your affidavit. Sure, we can all draft affidavits without case theories by we all know that we've got to give the background, we've got to provide the history of care, we've got to talk about family violence and all that sort of thing. But to be, particularly in drafting an interim affidavit where you've got the 10-page limit, you have to be more targeted and more forensic in your approach to drafting. And sorry, I'm deviating a little bit now and talking to solicitors about drafting, but as an advocate, as a barrister, I can only do what I can with the evidence I'm given. And the evidence I'm given is what is in the affidavit material. I can't make a case without the evidence, and that's why I count on solicitors to make sure that the evidence is in the affidavit. So your jobs as solicitors, and I'm assuming largely the audience is comprised of solicitors, your job is really important in terms of ensuring that you've put the relevant evidence in your affidavit so that your counsel can make the submissions at the hearing. Without the evidence, we can't make the submission. So you've got to adopt a forensic approach and have a case theory when you're drafting your affidavit, so you know why, what purpose the evidence is going to serve, okay, and what evidence you need to support the reasons to get you to the conclusion that you're asking for. I bang on a lot about case theory, but it is so important, and it'll feature as we go through the rest of the golden rules. Thank you, Dina. Can we move on to the next golden rule, please?
We did just have one question come through, just on when you say you start with your conclusion. What do you do when you have some facts that don't fit in with that conclusion that you want the court to make? Does that mean that you have to reassess what your conclusion is?
Not sure I really understand the question.
So you have I think what the person is getting at is you have your overarching case theory, and then you have some facts that might not fit in with the case theory that you have in mind. Does that mean you sort of need to go back to the drawing board?
If they are facts that don't matter, then it doesn't matter, because not always, you don't always have the perfect factual scenario. If they are facts that you know the other side are going to be using against you, then you're going to have to think about how you will respond to those and address those deficits or weaknesses or inconsistencies in your case in submissions. So that's not so much an issue for case theory. It is more an issue for preparing your submissions ultimately and anticipating the case of the other side. If I'm understanding the question rightly, Dina, I'm not sure if I am,
Sure.
but yeah, where there are problems in your case, where there are facts or where there are facts that are inconsistent with your case theory, you know that the other side are probably going to pick up on that and use that against you. So you have to be able to anticipate that and deal with it in your client's evidence, of course, but also in your submissions.
Great, thank you.
Okay.
There we go.
All right, the next golden rule is preparation. Preparation. I can't say it enough. It is it's important at any stage of your career and no matter how experienced you are, but it is all the more important when you are less experienced and are less confident as an advocate. To some extent, as you get more experienced and you're more confident, your preparation time is reduced and you can get away with less preparation. But I would certainly, I still, even after 25 years of practice and more than 15 years at the bar, more than 15 years as an advocate, I feel a little bit sick if I know that I am underprepared. I can manage it, I can cope with it, and I can probably still get away with it better than I could have a decade ago. But it's not a great feeling, and I don't recommend it at all. I don't recommend winging things at any stage of your career, but certainly not when you are first starting off. All right. So preparation means a lot of things. It means obviously reading everything and reading it carefully and reading it more than once. And when I say everything, I mean not just your own material, but the other side's material, the subpoenaed material, the tender bundles, all those things. And that takes time. And I know I'm preaching to or talking to busy practitioners, which is one of the difficulties with doing your own advocacy as a solicitor. I know you all have busy practices. You manage many files, ongoing matters, and finding the time to prepare matters properly is difficult. I appreciate that, and that is what makes it hard to do your own advocacy as a solicitor, and I fully appreciate that. But if you are going to do it, you have to do it properly, and you have to devote the time to reading, to also giving yourself the opportunity to think about the matter deeply. And that, for me, that means when I get a brief, for example, I'll read it once over, and then I'll put it away and I'll think about it for a bit. I'll come back to it. And that thought process, what I call the percolation process, is really important because it gives you the time to actually think beyond the surface level of the material. Formulating the case theory, so that takes time, and is, as I've said, a really important part of the development it's the first stage in the development of your submissions that you'll ultimately make at an interim hearing, for example. I've put there finding the spin. Please don't get me wrong, I'm not talking about spinning something that's rubbish or spinning rubbish, or spinning something that's unethical or anything like that. What I mean is, probably a better word is angle, finding an angle, finding what angle are you take, or what spin we're going to take, or how are you going to spin this so that it's persuasive? How are you going to sell it? How are you going to sell your client's case to the judicial officer? And how are you going to do that with credibility? Okay, so that's why I mean it's not about a rubbish spin. I'm talking about finding a good spin, a good angle, tweaking, nuance, whatever you want to call it, that's going to hook your judicial officer in, right? To get them to listen to you and to be persuaded by you. And that does mean, and that is part of the skill of being a good advocate, it does mean finding the angle, right? Finding the way of appealing to the judicial officer, because at the end of the day, judges and registrars are all humans, and they will find, if you want to persuade them, you've got to find a way of appealing to them with logic, appealing to them to some extent with on an emotional level. And I don't mean I don't mean being emotional, but on some level, if you can tug at the heartstrings, or you can appeal to sympathy, that might also be a way in. Okay, so finding the spin is important, and that's why you have part of your preparation. Developing your arguments, your submissions, obviously that's important. That's part of your standard part of your preparation. Anticipating the other side's case is also really important. So you cannot be blinkered in your approach to advocacy. You cannot just focus on your own arguments, your own submissions, your own case theory. You have to think about what the other side are going to say, so that you can anticipate the arguments against you and come up with the responses before they're even made, right? So you don't have to think about that on the spot. If you have anticipated what the other side are going to say about the problems in your case, you can deal with them up front. Take the wind out of the other side's sails. Acknowledge at the outset, right, of your submissions. I acknowledge at the outset, I've got these problems in my case. Respond to them as best you can, so that you take the wind out of their sails and then go into your own case. That's often a very effective way of dealing with the problems. You can't just ignore them. If you just ignore them and plow on as if you don't have the problems, your case is not credible, okay? So don't ignore the problems. Deal with them as best you can. Practice. I've talked about the importance of practicing. Talking out loud, practicing submissions, practicing talking to yourself in the mirror sounds silly, but this is all about oral communication. So knowing what you look like and how you sound is actually an important part of advocacy. Knowing your bench is a really important part of preparation. Unfortunately, these days, in the olden days, we used to go sit in the back of people's courts. Nowadays, that's happening less and less, but you still obviously can do that. So if you're going to be before a judge that you don't know, or a registrar you don't know, go and sit at the back of their court and watch them, because every judicial officer has their own idiosyncrasies, and you need to know what they are in order to have the best chance of achieving the outcome you want to achieve for your client. Talk to your colleagues, ask around, find out what this particular judge is like. Okay, and be well organized. Again, for juniors, right? People who don't have a lot of experience, don't have a lot of confidence on your feet yet, perhaps don't sound as articulate as you would like. If you're well prepared, the bench will be able to see that. Even if you're stumbling a bit and not as smooth as you would like to be, if you are well organized, your material is all there, you can put your hand on documents easily, you are across the material, you can answer questions, you know where things are, that all helps to come across in terms of your effectiveness and your persuasiveness. Okay, so be well organized. Don't be that practitioner who rocks up and just throws a bundle of loose papers on the table and looks a mess, because they look chaotic from the bench, and often sound chaotic, unfortunately. All right, next slide, please, Dina. Simplicity. That's my next golden rule. We spend a lot of time in law school. All of us have been through, I don't know, 5 years of law school, spending a lot of time reading very, very complex cases, judgments, very complex articles, and writing very erudite and complicated essays, 3,000, 4,000 word essays, trying to use the longest sentences, the biggest words, and the most complex structure language possible. What I say to my students at uni is that if you want to be an advocate, you've got to forget all of that, undo all of that, and not just an advocate, any legal practitioner, I think, but particularly if you're going to be an advocate, forget all of that, go back to simplicity. Use simple words, short sentences. And that's really hard for lawyers, a lot of lawyers. When how many times have you sat at the back of the court and heard people talk, and you just find it difficult to understand what they're trying to say, not because they're not intelligent, everybody is very intelligent, but because they do not speak simply. So if you want to be a good advocate, you have to learn to speak simply, to cut away unnecessary words. And that's important both in your oral communication and in written communication, in your written submissions as well. Simplicity does not mean unintelligent, dumb, anything like that. It's just good communication, and it makes things easier for the person listening. So when you think about how many cases an SJR or a judge deals with in a busy list, an interim hearing list, or how many final hearings a judge has heard in the last month, you think about how busy they are and how much information they have to take on. Wouldn't it be a pleasure for them to hear something that is simple, easy to understand, easy to follow, not brain straining, and not complicated? Not because they're not intelligent and they can't understand it, right? But because it just makes life easier for them. And if you want to be persuasive, making life easier for the bench is absolutely the key, okay? The concept of verbal pruning, it's a metaphor. Obviously, think about, flower, plant, tree, whatever it might be, and pruning, snipping away the bits that protrude. That was actually something that Judge Eldershaw taught me when she was my tutor, when I was a reader. Practice verbal pruning. Snip away at the words that are unnecessary. Adjectives are often unnecessary. I taught I did some advocacy training just earlier this week, and one of the participants used the phrase gaping gaps. And that's a really good example of an unnecessary adjective. You don't need gaping gaps. A gap is a gap, okay? You often don't need to say things are very serious. They're serious or very significant. They're either serious or they're not. They're significant or they're not. You don't need the adjectives. So just think about cutting away, and it's not it's really just a word here and a word there, but cutting away the unnecessary words to make things simpler and shorter and brief and succinct. That's the goal, not long and complex, because the longer you are, the more boring you are, and being boring as an advocate is not a good thing. Having a structure, I've talked about how having a good case theory helps you to have a structure. And of course, anybody knows having a structure makes it easy to follow. Because also remember that the judicial officer is taking notes. And if you can give them a structure to take notes, such as I have 3 points I'm going to address, they are 1, 2, and 3, dealing first with the first point, and then elaborating next the second point, elaborating, and next the third point, you can imagine what their notes are going to look like. It's going to be exactly the way that you've just spoken to them in, as opposed to rambling narrative without any structure. You can imagine what their notes are going to look like, and it's then going to be hard work for them to make something of it. Okay, so make it easy. Bluff, it actually stands for bottom line up front. And that's something that I was taught when I was a baby barrister. Make sure you tell the court what your bottom line is straight up. Okay, where are you heading? What are you seeking? What's the ultimate conclusion that you want the court to come to, so that the listener knows where you're going. Whereas if you talk for half an hour, 45 minutes, and then get to the bottom line, the person's been listening for half an hour or half an hour and not knowing what they're listening for. Whereas if you tell them straight up, this is where I'm going, then at least they know what to listen out for and have a better chance of following you. Brief and succinct, I've talked about the concept of aiming for the red dot. If you think about a red dot, it's short, sharp, it's precise, and that's what you should be going for. Lots of analogies here, but take what you will. But that's what I think about when I think about submissions. I think about going for a red dot, okay, as opposed to a smear. Okay, and with the law, know the law. Obviously, you must know the law, but don't lecture on it. You don't have to tell the court that the best interest of the child is a paramount consideration, and that Section 60cc says blah, 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 and blah. You just don't need to do that. You can assume that the court knows that. Obviously, refer to the law where relevant and be prepared to answer questions about the law. So, for example, where does this fit in Section 60cc, right? You've got to know that, but you don't have to slavishly go through that in your submissions. It's a pretty boring way of structuring your submissions. You could do it. It's not wrong, but it's pretty boring. All right, next slide, please. Okay, clarity and delivery. So this flows from simplicity, okay? Simplicity and clarity is what you are striving for as an advocate, and it's really hard. It's really hard to be simple, and really hard, ironically, to be clear. A lot of things go into clarity of delivery. First of all, in terms of the way you speak, your pace, your volume, your tone, the extent to which you have variation in your tone and in your tone, in your voice, and pauses. All of those things. I could talk about clarity for a whole hour. I don't have a whole hour, but I could certainly talk about it. Pace is important. Most of us, when we are nervous, talk too fast. So you have to be conscious of that and be conscious of it and stop it. Okay, so don't talk too fast. If you talk too fast, you will lose your audience. If you lose your audience, you will not persuade. Simple. If you don't persuade, you won't get what you want. Remember that most of the judges are taking notes, or registrars are taking notes. So you've got to speak at a pace where they can keep up with you. Okay, but not too slow is not good either. Too slow is boring. And as I've said, no one likes a boring advocate. So be conscious of that as well. Volume, there is nothing more annoying for a judicial officer, although, well, no, actually I won't say nothing, but one really annoying thing is when they can't hear. So you have to project your voice. Again, if you're a junior and you're nervous, you just have to learn to project your voice so that you can be heard. If you can't be heard, then you've got no chance of persuading. But by the same token, don't shout. There are those advocates, we've all seen them, who shout at the bench. Shouting is not good, it's not polite, it's not respectful, it's not appealing. No one likes to be shouted at, so don't shout either, but speak loud enough to be heard. Tone is really important. Some people think that an aggressive tone is appropriate. I certainly don't. I don't think judges generally find it appealing. It might be good to put on a show for your client, but that's not why we're there. So an aggressive tone does not come across well. And we've all seen it. We've all watched aggressive advocates, and it just doesn't sit well. It's not appealing. It's a little bit embarrassing. So don't do it. Okay. A polite and respectful tone, sometimes even a sympathetic tone, as in is not necessarily sympathetic to your own client, but an empathetic tone, but not sympathetic. Empathetic tone is probably the best, but always polite and respectful because you want it to appeal. Variation in tone. Some advocates have one gear, and that's the same gear they're on the whole way through. What I find more interesting is if you can actually vary your tone, okay? Vary your pace. There are times when you will be quiet and talk quite quietly, and then when you you might ramp it up and increase your not aggressiveness, but increase the intensity of what you're saying. That can be really effective. So use variation, use light and shade to make it interesting, to be appealing, to be persuasive. And don't be afraid of silence. Most people are really nervous about any moment of silence in the courtroom. It feels like everybody's looking at you. But actually you can use pauses to your advantage and to some dramatic effect. I'm not saying be dramatic, okay? It's not NIDA, but you can, if you've made a really good point and you know it's a good point and it's well supported by the evidence and it really lands, pause for a moment and let it have some effect, okay? That's all I'm saying. Pause between your point 1, your point 2, and your point 3. So that there's a clear delineation in what you're talking about and structure. Okay, pause so that the judge will know that you're at the end of that point, and then before you move on to your next point, just pause a bit. Let them catch up, right? Let them have a moment just to consolidate that point, and then start your next one. Okay. Pauses also help in terms of breathing, and breathing helps and is essential. You must breathe when you are on your feet, because otherwise, if you don't, you will pass out. That's one thing. But also it helps to keep your pace under control, and to keep your nerves under control. So pausing will give you time to breathe. Okay. Eye contact is essential. Advocacy is all about communication. And you can't be a good communicator if you don't make eye contact. You will lose your audience very quickly if you don't make eye contact, if you're just looking down and reading your notes. And that's why I say to all my students and anybody who wants to listen to me about advocacy, you can't expect to write out your submissions and read them. It's not a speech, it's not a monologue, and it is boring to listen to someone read. And also when you read, you tend to speak faster, right? Because you're just looking down and you're just reading words on a page. So by all means, write out as many notes as you need. You write out your submissions if you need to, but don't read them. Okay. I often find that once I've written them out, I don't need to read them. I know that they're there. I can refer to them if I need to, but I'm more confident in talking to them if I've written them out. Some people just do dot points. That's a skill I'm not yet at yet. I haven't got that skill yet, but if you're able to do that, then great. But just if you have to write it out, that's fine. Just don't read. And if you are going to read, practice making it sound like you're not, by having those pauses, by looking up and making eye contact, all of those things. Make it sound like you're not reading. Okay. Body language is important. Be conscious of things that are annoying or distracting, like hair flicking, pen clicking, hands in pockets, crossed arms. Never address the court with crossed arms. I see a lot of people doing it. Perhaps in cross-examination, sure. That might be a little bit of dramatic effect that you could use. But when you're addressing a judicial officer, I think addressing someone with your arms crossed is very disrespectful. Similarly, with hands in pockets, I think is too casual and disrespectful. Best place for your hands is on the lectern. One on either side of the lectern. That stabilizes you. gives you something to hold on to, something to do with your hands, or both hands on the table, right? Just so that you're stable. Try not to move around too much, and because that's annoying. That's distracting. If you're just doing this the whole time, it's annoying. Use of aids. I don't want to talk too much about this, but think about it. If you can be helpful, all right, and being a good advocate is all about being helpful. If you can provide maps to show distances, if you can provide schedules of drug testing results so that the judge doesn't have to go through 50 pages of raw results, summarize them in a table. If you can provide a chronology that's targeted at something in particular, for example, if you're trying to show that there's been non-compliance with orders repeatedly, just do a chronology that just sets those things out. Be forensic about it. Use those things as aids to help you be persuasive. And managing nerves, look, we all get them. And you have to find your own way of managing, whether that is deep breaths at the bar table, perhaps, some people play with a wedding ring or something like that, or a ring on their finger just to have something to play with that's discreet. Whatever it might be, you have to find a way of managing those nerves. Nerves are fine, and a bit of adrenaline is a good thing, but not if it completely takes over and you're not able to speak properly or conduct yourself properly. So you have to learn to manage. All right, next screen, please, Dina. Okay, watching and listening. So this relates to eye contact. What I've said is eye contact is important in terms of your communication and being a good communicator. So if you want to get through to somebody, looking them in the eye, which is really hard in Teams hearings because you're not actually making eye contact with anybody. And I find that really disconcerting, one of the reasons why I don't like Teams hearings. But if you're in person, you can make that eye contact, and that's really important. But the other reason for eye contact is you've got to watch what's happening on the bench. Look and see whether your judicial officer is distracted by something. Are they fossicking around trying to find a document? Are they looking at their computer with furrowed brow because something's crashed or they've not been able to access a document online? Are they talking to their associate about something? If they're distracted, then they're not listening to you. And if they're not listening to you, they're not going to be persuaded because they're not hearing what you are telling them. So if you see that, you won't see that if you've got your eyes down looking at your notes. Okay, you will only see that if you're looking up. If you see that, then pause and wait. Wait until they're listening to you and you can see that you've got their attention. Otherwise, if you don't have their attention, then they're not fully engaging with you. So that's another reason for eye contact. But also, looking up and watching your judicial officer will give you some clues as to how you're going. So if you're getting nods, that's great. Love nods from the bench. Okay, you can you know that you're probably doing all right, and your submissions are probably landing. If you look up and you see shaking of the head, furrowed brow, eyes rolling, not that any judges would ever do that, then you know that you're not quite getting there, right? You're not. It's not landing. You're not convincing them. That gives you a chance to do something about it. But if you're not looking up and you miss it, then you miss that chance. So there are certainly times, and I don't recommend this for baby advocates, baby practitioners. If it's your first few times on your feet, I wouldn't suggest doing this. But once you're a bit more confident, if you see that your judicial officer is shaking their head or furrowing their brow or frowning, you can actually say, Your Honour looks troubled by that submission. Can I assist? Or Your Honour looks troubled. Is there something I can do to assist Your Honour in regard to blah, blah, blah? Okay. You can actually politely inquire. And I think most, if not all, judicial officers would be appreciative of that, because at the end of the day, your job is to meet their needs. Okay, if you want them to do what you want or what your client wants, you have to meet their needs. You have to help them. And so if you're respectful enough to ask and to, first of all, notice that they're not that they're struggling or not with you, and you ask them if you can assist, they might actually say to you, well, yes, Mr. So-and-so, I don't really understand that submission. And then you've got the chance to have another go at it, okay? Or they might say, yes, I am troubled by this, and this piece of evidence. Then you've got a chance to go to what's troubling them and address it. Whereas if you miss it, then you don't get that chance. So it's actually a chance to have another go to try and address the thing that is bothering them about your case. You might not be able to, but at least you're giving yourself a chance by watching how they're reacting. Okay. If you do get asked questions by the bench, and I know this terrifies most people when it comes to advocacy, please answer the questions promptly. Please don't say to a judge, can I deal with that later? Because first of all, it's pretty rude, I think, to fob off a judge or a registrar who's asked you a question. It's obviously something they want to know. And to tell them or to suggest or to say to them, I'm going to deal with that later, really is quite disrespectful in my view. But secondly, it disadvantages you, because for the rest of the time while you go on about something, whatever it is that you want to talk about that you think is more important than answering the judge's question, the judge has still got that question on their mind. That thing that is bothering them is still bothering them the whole way through while you are jabbering on about something else. Okay, so they're not listening. They're not listening to what you're saying, or not fully listening to what you're saying. They're still thinking about that thing, that question that they want you to answer, and it's not helping. Okay, so if you're asked a question, answer it promptly, answer it as best you can. If you need time to be able to answer it, if, for example, it's a question about an authority that you know nothing about and you need to go and get the authority and read it, then of course say, I'm not familiar with that authority, could I please have a short adjournment to read it or to familiarize myself with it? That's a different issue, right? But if it's something else that an adjournment's not going to fix, right? And you just simply don't want to answer it now because it's on page 2 of your submissions and you didn't prepare to answer it out of order. That's not a good enough reason. Deal with it, answer it as best you can. It may well throw you off track, but you've met the judge's need. Okay, you've dealt with something the judge has raised, and then part of the skill of an advocate is to come back to where you were and be able to keep going. All right, judges will throw you off track all the time. You've got to be flexible, which is why you can't expect to read a speech or a monologue. It's why you have to be flexible. Okay, all right, I think we're up to the last screen. Credibility. Credibility is an important thing. All of these are important things, but credibility when it comes to being an advocate is important for 2 reasons. Firstly, it's important in terms of the credibility of the argument that you are making. If you want to be persuasive, if you want to, if you want to achieve the outcome that you want and your client wants, then your argument has to be credible. And in order to be credible, it's got to be logical. It's got to make sense. Sounds really simple, but a lot of the time you hear arguments that don't make sense. Okay, so that's the first thing. It's got to make sense. It's got to be founded on evidence. I talked about that right at the start. If it's not supported by evidence, it's not going to be credible. And it's got to be restrained. A lot of the time, I see advocates going too far unnecessarily, over-egging things unnecessarily. A good advocate is one who knows when to stop, who only goes as far as they need to. And this extends to cross-examination as much as to submissions. All right. One of the golden rules of cross-examination is that you know when to stop. You only go so far as you need to. Excuse me, same thing with submissions. You only need to go so far as you need to. Sometimes if you push too hard, it actually doesn't assist your case. It makes you look like you're trying too hard. And then the judicial officer may well wonder, well, why is it that you're trying so hard? Is there a problem? It's so being restrained is actually a real skill in being an advocate, but it takes confidence to be restrained. It takes confidence in yourself that you have adopted a forensic approach and you've been able to identify the strengths of your case and you're not missing anything. So I appreciate it takes confidence, experience, but aim for it. And not blinkered. What I mean by that is obviously not blind to the deficiencies in your own case. If you acknowledge those as deficiencies and weaknesses, then that adds to your credibility, the credibility of the argument. What is also important, though, is the credibility of you as the arguer. And that comes down to things like the extent of your preparation. Your attention to detail is really important. I find for all legal practitioners across the board, good attention to detail is such an important skill to have as a legal practitioner. Preparing a document that is not full of typos, formatting errors, any other kind of mistakes. It sounds trite, it sounds too simplistic, but that a well-prepared and accurate document presents so much better than one that is full of mistakes and typos and formatting problems. But also credibility really comes down to your reputation. And that's something that advocate or not an advocate across the board, all legal practitioners must work on having a good reputation. It's hard work to build up a good reputation, and it's easily lost. Lost in a moment, okay? Lost in a moment, really easily. But particularly, I speak now to those of you who are in your first few years of practice, work on that reputation, because when you're on your feet, the extent to which a judge or a registrar knows you and can trust you when they ask you a question like, is there evidence of X? And you say, no, there's not. They have to trust you because they're not necessarily going to look through and check whether you're right or not. Okay, if they can trust you, if you've got a good reputation, then you are ahead in terms of your credibility and your persuasiveness. So work on that and on ensuring that you protect and preserve your own reputation. Dina, I think I've got to the end of the slides with
Yes,
3
yes,
minutes
you
to spare.
have. So we do have time for just one or two questions. So we've had someone ask, what do you do if a judicial officer keeps cutting across you or won't let you finish the submission that you're trying to make?
You just have to roll with the punches. What can you do if you try to, if you rise and say, would you, something rude like, can I just finish my submissions? That's just going to get you into hot water. It's just going to get their back up. You're just going to, you don't roll over either. You don't completely, you do have to be firm and try to finish your submissions, but don't be rude about it. Don't say things like words like, well, if Your Honour would just let me finish my submissions, which I have heard come out of people's mouths, just is so grating, and you will not do yourself any favors. So yes, it's difficult. It is difficult. That's what makes advocacy difficult. You will have some judicial officers who will cut across you, who will interrupt, who won't let you finish a single submission. You just have to roll with the punches and do your best. And answer their questions, go where they want you to go, follow their lead. And then at the end of it all, if you've still got things to say, come back to it. Is best I can say, but some will give you a hard time. There's no doubt about that.
And I think maybe the only thing I'd add there is just to try as much as you can to keep your cool. It's hard when you're trying to get your point across and you're being cut across, but just try to
Sorry,
stay
Dina,
calm.
you're cutting out.
Oh, okay.
Sorry,
well, I
Dina,
might move on just quickly to the next question. Any tips to improve your virtual advocacy?
Don't interrupt. Judicial officers often say this, that in the virtual environment, it's so much easier to talk over each other because you don't have that moment like you do in physical court where you've actually got to stand up before you speak. You just open your mouth and words come out of your mouth, and everyone does it. it's so much easier and so tempting when that's all you have to do, and you don't actually have to stand up before you speak. I think that moment where you have to stand up actually makes people stop for a moment and think about whether they should do it or not. So don't interrupt. I don't know what else would improves virtual advocacy. I think somebody said yesterday, trying to ensure that the picture of the person you're speaking to is nearest to the camera. If you can pin it in that way, I'm not really good at that. So that you've got some hope of looking at them. Whereas if your camera is off there, it's really disconcerting for someone to be looking over there when actually the lack of eye contact is even more noticeable. Other than that, no, I hate virtual advocacy. It's hard. It's hard work, and being physically in the courtroom is so much better.
And we've just had one final question come through. Is it respectful to say to the bench that you need to seek further instructions if you cannot answer a question and need to seek those further instructions from your client?
Oh, look, don't make things up. So, a golden rule, and perhaps that should have been one of the golden rules, don't make things up. So if you cannot answer a question without obtaining further instructions, then absolutely ask for the time to obtain further instructions. Hopefully it's not something that you ought to have instructions about already, but even if it is, so be it, you don't have them. If you need them in order to answer the question, then if you can't do it very quickly by turning around, and can I just say in terms of politeness, if you're ever going to turn around to speak to your client and your back is to the judge, always excuse yourself. Always a polite thing to say, would you want to pardon my back or excuse me for a moment while I speak to my client? Because turning your back like this is actually really rude to the bench. But by all means, if you need to obtain an instruction, either do it quickly, or if you need a short adjournment, then ask for it. Because you cannot make things up in answering it. Well, you can't make things up full stop, but certainly when you're trying to answer a question from the bench, please don't try and make it up.
All right, well, I might wrap it up there. Thank you so much, Karen. That was so informative. I feel like I really took a lot away from that. And to everyone dialing in, we do have part 2 of our webinar series on the 24th of September. So that's next Tuesday at 4:30. Everyone, please join me in thanking Karen.
Thanks, Dina.
And we'll see you next week.
Thank you.
Bye.